trust funding checklist that you have, turn to that. I just talked with a family member last night from Florida, my in-laws. Like, yeah, we did our trust, 4 years ago, but we never put anything in it. Great, you got, wonderful, we get to go through probate. So the most important thing, so just visually think about it, is, yay, thank you. Okay, so, so think of the trust. The trust is, we built a house, okay? Visually, we built your house. We designed it, we decided you wanted 4 bedrooms, 3 bedrooms, 2 bathrooms, whatever. We built it. That's signing the legal documents. When we sat down at our last meeting together, we signed all those legal documents. What do you do after you build a house? You want to watch and stare it and drive by it and see that it's a nice, beautiful empty house. You want to move in. So you want to move your stuff into your house. That's the whole process of trust. Bank accounts. This category, I'm just going to talk about typical, traditional checking accounts and savings accounts. The things that you would use to just store monthly operations. Each bank deals with these differently. I have experience with a lot of the different banks. Just when I think I know how that bank is doing this, someone goes to a different branch and gets treated differently. So I will tell you that the one consistent bank that I have had trouble, or that my clients have had trouble with, is Bank of America. And it can just be a challenge. So what you're doing with your bank accounts, with your regular day-to-day checking, your savings accounts, is you're taking your trust certificate, that 2-page version that you got, and you are taking that, you're walking into the bank and you're scheduling an appointment with a personal banker. If they have someone available, then great, you can meet with them right there. But usually you want to meet with the most senior personal banker in the branch. If you have a relationship with one of the bankers, that might work too. But you don't want to go to the tellers. They don't do this work. They do deposits and withdrawals. So go over to the personal banking side and sit down and talk with someone. The sentence all you should have to say is, I've set up my trust, and my attorney said I need to make my bank account owned by my trust. That should be all you have to say, in theory. Usually what you have to do is arm wrestle them to get this done. That's okay. So you pull out your trust funding checklist and you show the banker and you say, here's my bank account on this list that my attorney created. It's owned by me, right? They can confirm it's in the system, or me and my spouse. He wants it owned by the trust. How do we make that happen? Here's my trust certificate. They are supposed to not require a new account number of you. Okay? If it's going from an individual account to an individual trust, or it's going from a joint account to a joint trust account, the account number does not need to change. And so you have the certainty of your lawyer, who's done this hundreds and hundreds and hundreds of times. You have my back to push against them and tell them that that's how it's supposed to work. So they'll fill out a bunch of paperwork, they'll look at your trust certificate, and then you sign a bunch of places, and that should take care of your checking and your savings account. That's for bank accounts that you can walk into the branch. There are more and more accounts that are just strictly online. If you have accounts at Capital One, if you have accounts at, what are some other online ones? Ally Bank. There's a few others, but if it's purely an online account, you're going to do 2 things. You're going to try to see if you can do it all in your online account. Log in, username, password, go to their customer service section and see if you can figure out how to do that. Sometimes you can do it directly online, put the trust name on the account. If you can't, then you have to call their 800 number and go through that same exercise, but just over the phone that I talked about as if you were sitting in the branch. Go for it.
Yeah, does the bank then change the name of the account? I did this. I gave them the 2 pages, but I I didn't notice, and there was no change in the number, but I don't remember that there was any change in the name of the account on the statement. Is that correct?
Yeah, it should change the at the top of your statement it's got your name and address. It should change that in some way, at least to say, your name with maybe the letters TR after it, or under your name, your individual name has got your trust name. Each bank will do it differently. I haven't seen any that actually don't change that at all.
Maybe it did, and I just didn't notice.
So you might need to either confirm that with them or make sure they actually did make the change. So the online ones, you're gonna have to. You're gonna have to call their 800 number, but they'll do the same thing. They'll basically mail you or tell you how to download a packet to change your account registration into the trust name. You sign it, usually notarize it, and mail it back in, and then get in there about a month later, download an actual statement, or if they email them to you, download it, open it up, and make sure, like you just said, at the address on there, make sure it indicates some type of trust or trustee designation on that mailing label. So that's checking and savings accounts. Any questions on checking and savings accounts other than that one? You have another one?
Yes, I have one other one.
Go for it.
You mentioned that if you put somebody else's name on there, they, with regard to real estate, and I'm wondering about bank accounts, do they become liable? For example, I guess what I'm thinking is that if I designated a trustee, another trustee gave them power of attorney, I no longer can keep my checking account straight. So I name one of my successor trustee to it, give him the power of attorney.
Yeah.
He has the power of attorney on the checking account. Now, is he liable if I go out and kill somebody or something?
No, and that's exactly why it should be set up in this way. Either the trust is the preferred way, set them up as a successor trustee. The other way is to set them up as a power of attorney, but that's usually less efficient. There's a lot of hiccups with that. So setting them up as a trustee does put their name on the account, but it puts their name on the account in a fiduciary capacity. And that's what's important. That means they're legally holding that account all 100% for your benefit. So that if they went out and got in a car accident, they're liable. They can't at all get to that because it's not for their benefit. That's what the trust document controls. Does that answer your question?
Yeah.
Okay. Okay, that's checking and savings accounts. Personal property. So personal property is just tangible stuff, furniture, electronics, anything that you can pick up around the house. It legally also includes money, cash, vehicles, but for this context, let's just think about stuff sitting around the house or in the garage or wherever. I'm going to have to move over here and take up a little bit of your space, John, because my battery's going to give up on us. Can I just do that corner? Okay, thank you. All right, so with personal property, we're talking about that. None of those things have title documents, right? So what's the old saying? Possession is
9/10 of the law.
9/10 of the law. It actually is true with the case of personal property. That's still the controlling law. If police walk up and you're holding the thing and somebody else says, no, that's mine, well, the police are going to presume it's owned by that person. And so the reason it's important that we address this is because when you're not around to say who owns my stuff, if there's any dispute among your family about who was supposed to get things out of the house, if somebody has already got something out of the house, there's not a lot of legal control to get it back. Okay? It's really hard. I have a client that just went through a big, long battle basically over the personal property. And because there was a really sympathetic judge who knew the defendant, because the defendant had already created a reputation in the community of being a real scoundrel. It was a small community. The judge ruled and said, I don't care what you have to do, go get all the items and bring it back. And so they got it back, but it's really unusual. So with personal property, we want you to put as much effort into that as you think is necessary. Okay? Stuff in my house, if my house burnt down, there's like 5 things I would want to make sure I get out of there. You know, that's kind of the test. What are the things you would want to make sure got out of the house in the case of a fire? Everything else, whatever. But the things that are that important to you, make sure you either create a list of those items and put it in your trust binder, or use the personal property memorandum that we give you that's got a little form with blanks and columns where you can say, I want I want Johnny to get the sofa or whatever. You can designate those things. The reality with those personal items is not that you might not care so much who gets what of your personal items or your jewelry or your antiques. But your family might have their feelings hurt if they didn't know you wanted brother to get that, right? And the last thing we want to do is leave that kind of feeling behind, right? We want to make sure this feels good, that there's not feelings hurt. I mean, we're not, trying to walk on eggshells, but we're also not trying to create problems for them. So if there are things that a family member or a friend wants that wall hanging, and you're okay with that, then just give everybody permission by filling it out on that sheet. So yeah, it's okay if my neighbor Susie comes and gets the whatever. Then everybody will know. Okay, I didn't know that, but yeah, it was okay with mom or it was okay with dad. That gives everybody permission to do it. We give everybody here, everybody's in the room almost everybody in the room has a form from us that declares all your personal tangible property is owned by your trust. It's a very generic statement that lists it all out: my furniture, my clothing, my jewelry, my collectibles, my artwork. So we have a general way of knowing that you gave your trustee permission to deal with all that stuff when you couldn't. And what that does is that would allow them to arrange for, any gifts you've mentioned, but also to arrange for an estate sale. That makes it so there's one less hurdle for them to just call the estate sale company and get that whole thing taken care of.
Francisco, your displays.
I know, it's dying on me. I'm sort of mad at it. There wasn't a ton of substance on this. It was more to remind me to cover this stuff. Is it back up? Mm-hmm. Okay. Any questions about personal property? Anybody heard of any weird stories about personal property issues? They happen. Business interests. With that line, we're talking about if you own a little consulting company, you own a rental property, or you've got a little LLC floating around somewhere. Those are they can be very easy to deal with if they're set up the right way. An LLC is just like anything else in the stock market. It may not be a physical piece of paper, but it's a piece of intangible property that you own. You own the LLC. So just like everything else you own, it has to be re-registered in the name of your trust. So you want the ownership of that to not be me, Francisco Sirvent. You want it to be Francisco Sirvent's trust. So if you have business entities, you usually have to get consent of any other co-owners, if there are co-owners. And there can be transfer restrictions and other kinds of elements that you got to be careful about in that when you're dealing with business interests. But definitely you want the ownership of those to be changed. It's not a thing that only happens after you pass away. Life insurance. Okay. This one is usually kind of a funny one because we all are traditionally taught that life insurance, it goes automatically after our death. It skips probate. It's tax-free. We don't have to include that in our estate plan at all. I like to include in the estate plan for a number of reasons. There's 2 types of life insurance policies when you really break it all down. There's the type that builds up cash value, and there's the type that doesn't. the type of life insurance policy that builds up cash value. Cash value, what does that mean? What do you think that means?
You could turn it in before you die and
You can get some cash.
get some,
You can get some cash, right?
Right.
It means it's like money. It's like money in the bank. So that type of life insurance policy, even though there's all these weird restrictions and maybe penalties if you do that or fees associated with it, it's treated as cash. So those types of policies, you want them to be owned by your trust, just like you would a checking account or a savings account. For two reasons. If you become incapacitated, okay, if you cannot pay your bills, you're not able to take care of your own stuff anymore, and somebody else is doing that, and all of a sudden they're, crunching your budget and looking at your numbers and they go, oh, we really wish we could pull some of this cash value out. If they're not authorized, if they're not the trustee of that account, if that account's not, or if that life insurance policy is not owned by your trust, they may not be able to get to the cash value, which might be really helpful while you're alive sometimes. So having those policies owned by your trust totally solves that problem. The other type of policy that doesn't have cash value is usually called term life insurance, and that just, you pay your premiums, you get nothing, you can't take the money back, but if you die, there's a lump sum benefit. It only pays if you die. And whenever you open a life insurance policy of either type, they will make you fill out a beneficiary form, right? So you've got to say on there. So there almost is always a beneficiary already designated on life insurance policies. On both of those, I'm going to scoot over here a little bit because this is about beneficiaries. On both of those types of life insurance policies, we want that death benefit to be your trust. Because your trustee, that one position that you've designated to oversee and administer all of your affairs, might need that money to pay some bills, might need that money to make allocations among your beneficiaries, make the division easier if they've got that pot of cash they can use to offset other buckets. One beneficiary says, well, I'd rather have the house rather than split the house. And the other one goes, great, I don't want the house, I just want a pile of cash. Well, now they can make that allocation at the time. And if there's a tax bill due, an income tax bill due on other assets, that life insurance can sometimes be used to pay the bill and let the beneficiaries take the assets with less of a burden, less of a tax burden. So being able to coordinate your life insurance with all of your other assets can give your trustee a lot more flexibility to really work out the best plan of distribution after we're gone. Yes, life insurance death benefits are tax-free. They're still tax-free whether they go through your trust or not. So we don't lose that benefit. Life insurance benefits in Arizona are also exempt from creditors for a certain amount of time after somebody dies. If you pass it through the trust, it gets the protection for as long as they keep their trust going. Okay, so it can really step up the level of flexibility and protection that beneficiaries get on a life insurance death benefit. Any questions on life insurance? Yeah.
This isn't exactly life insurance, but the long-term care insurance.
Okay.
Should that be in the trust?
So I don't have a specific line for that, so let's just get right to it. There are, I don't know how many types of actual long-term care policies, but they still break down into these two types. Either it has cash value, where you could say, I don't want the policy anymore, give me whatever my money left or whatever my money is back, and you get some cash. And then there's the type of long-term care policy where you pay your premiums and you only get something from it if you need the long-term care benefit, okay? So if it's that second type, if it's the type where it has zero cash value and you're literally just paying like a health insurance premium, that's what it feels like every month, you don't have to do any funding. Your trust doesn't have to be registered on it. Your trust doesn't need to be the beneficiary. It's completely tied to you as an individual because it's an individual health policy. If it has cash value, however, you want it owned by your trust for the same reason. Now, usually if you're becoming incapacitated, you're going to want to get the benefits. You're not going to want to get the cash back because the benefits are a lot higher than the cash. But in some weird scenario, there's some other pot of money that we're using, or there's multiple long-term care policies and we're going to use this one, but having it owned by the trust gives your trustee the flexibility to decide what the best financial move is at that time. Yeah. Does that answer your question?
Yes, thanks.
Any other questions on life insurance? Okay, let's jump down to investments. Let me look ahead really quick. Okay. Investments, all we're talking about with investments is non-tax deferred investments. I'm going to get to IRAs and 401ks and annuities on the next slide. These are either stock certificates that you hold. I own 10 shares of Disney, and Grandpa left me this actual real certificate or something, right? Or you open an account at Fidelity or TD Ameritrade or whatever those other companies are, and it's just a Francisco P. Sirvent investment account. And I can buy and sell stock, mutual funds, all kinds of different things inside that account. That's what this refers to. Those are treated just like your checking and your savings account. You want them owned by your trust. Currently, you want to get them owned by your trust now. For all the reasons that we've talked about with the other assets. If you become incapacitated, we've had clients where those get frozen and nobody can access them. Even if there's a power of attorney, we've had the account, one was at Edward Jones, we had another one at Fidelity, where when they got wind of a client's, one was in incapacity, one was near incapacity, they froze the assets. They said, go get a conservatorship started. We're not going to take any liabilities. Power of attorney, we don't care. They just didn't care. So having it owned by your trust, I've never had any accounts get frozen due to incapacity because these institutions are very well protected when it's owned by a trust. When you open a trust account, you're telling them, I'm taking liability for who owns and manages this account. Right now, I own it as the trustee because that's what I want. If I become incapacitated, I want my next person or my spouse or whoever to have that to be the trustee. But you are saying, I'm controlling that decision. And they are well protected nationally among the 2,000 estate planning attorneys that I work with in Wealth Counsel. Nobody has had issues with accounts with investment accounts held in trust getting frozen. So you want those to be owned currently by your trust. Miscellaneous items. This is just to me ask if there's any other question about assets that might need to be currently owned by a trust that anybody wants to ask right now. Go for it.
The one I have is Ameritrade, even though I just use it as a savings, an alternate savings account, and that has to be put into the trust. And I continually get papers from them. Now they're asking for an ID.
So that's a great question. Tax ID number?
A photo ID containing your signature for each signature on the form.
Oh, so that's just your driver's license.
And a notary stamp for a signature.
Okay.
And a representative, and I have to talk to a representative in order to fill out the transfer of death benefits.
Okay.
So
since you mentioned that, let me just cover it. With your trusts, while you are alive, even beyond the point of incapacity, even if somebody else is acting as your trustee, the whole time we're alive, up until we pass away, your trust has the tax ID number of your Social Security number. There's no separate new tax ID number created. There's no separate tax return that gets prepared. It is the exact same individual income tax. Same thing happens before you set up a trust and after you set up this type of trust. So your tax ID number doesn't change. So as you're filling forms out, when it asks for the tax ID number of your trust, you just put your Social Security number in there.
okay.
Yeah. Good, I'm glad you mentioned that. Okay. Beneficiaries. So we talked already about life insurance. I will mention that life insurance can sometimes be worked into a plan in a really nice way. If you want I want my trust to go here. I want all my trust assets to go here. But I really want to benefit somebody else on the side, but I don't want them to know anything about my trust. We have, some clients that like to keep things secret. Go figure, right? Well, a life insurance policy can be a nice way to do that. Because you buy it, you pay the premiums, you designate that person as beneficiary. As soon as you pass away, they get notified and they just cut a check. It has no involvement in the trust. Because what happens after we die with a trust is the beneficiaries get a copy of the trust. That's legally required. So if you have a desire to leave some gift outside of that plan, you can do that through a life insurance policy. And that would be one time where we would say, don't make the beneficiary of that life insurance policy your trust. Just make it directly that individual. Make sure you name a contingent.
Could it be an organization?
Yeah, could be an organization. If, again, like a charity.
A nonprofit?
Yeah, if it was going to be a charity, I would still funnel it to the trust and designate that charity as a beneficiary of your trust, because we can use that to coordinate and do some tax planning. And actually, you usually end up getting all of your beneficiaries a little bit more money by paying less in taxes. So the next two, annuities and retirement plans, I'll just kind of cover those together. Annuities wasn't on my last slide, was it? Okay, annuities. Annuities, there's lots of types of annuities. They break down, and I don't have that succinct of an explanation on how many types there are. But there's annuities that have money you can pull out. If you can pull money out, and the money you pull out is just you're getting your money back, it's not an IRA type distribution, then that type of annuity needs to be owned by your trust as well. Okay, so let me backstep a little bit and make sure I've said that. There are annuities, you take money, you dump it in, you say, I'm not going to need that for 10 years, and it's like a little CD, it's growing slowly, and you can get the money back out. If it has that kind of cash value, and you don't get taxed when you take your money back, that type of annuity should be owned by your trust. Okay? The other type of annuity and retirement plans are usually fall under the tax rules of being tax deferred. And you could probably get up and talk about this way more educated than I could. No, if you're shaking your head, okay. They're all tax deferred. So you put money in there, and you get some type of tax break for doing that. Whether now you get a tax break on it, or later you're going to get a tax break on it. But either way, it's a tax qualified account. They're called IRAs, 401ks, Roth IRAs, 403bs, any other types? 457. There's a bunch of these where you're putting money in, usually while you're working, and then at a certain age, you're required to take some money out of there. That's 70 and a half for most of these accounts. Those accounts, because they have all the tax rules wrapped around them, the tax benefits exist only if you leave those accounts in your individual name, okay, while you're alive. You just have to. So on those accounts, even if you're married, so my wife and I, we each have IRA accounts, we're not joint owners of those. She owns hers, I own mine. That's how the tax rules work on these accounts. So don't change the ownership on any tax-deferred IRA, 401k, Roth. You'll get a big warning back from the institution if you try, saying, oh, if you do this, you're going to get a big tax bill. So luckily there's some protections in place if you were to forget and try to do that. What we want you to do with those types of accounts is coordinate the beneficiary to your trust. Generally speaking, you want to, if you're married, you name your spouse individually first as my primary beneficiary, okay? And on your trust funding checklist, there should be an example, third line down, under the beneficiary column. That's how we kind of indicate it on there. It just says spouse first / trust second. So you'll name your spouse as the primary beneficiary individually. Okay, the reason we want you to do it individually is because a spouse who a surviving spouse has a special rule that they can take advantage of. So if I pass away, Nicole is my primary beneficiary on my IRA. She doesn't get paid that money. She doesn't, she gets to elect the option of taking what's in my IRA and just pushing it into her IRA account. So she gets to just merge the two. It makes it easier for her to deal with that account going forward. And that lets her continue to defer the distributions of those accounts. So that's why we still say spouse first on annuities, on any type of annuity, and on all tax deferred retirement accounts. As a contingent beneficiary, we want you to name your trust. Or if you're single, you name your trust as your primary beneficiary. Who remembers why I said we want you to name your trust as beneficiary of the life insurance policy? Remember all those benefits?
The trustee can use the life insurance benefit, the cash, to help pay bills or whatever.
Yeah. It basically gives your trustee, who is the person you've designated to oversee and administer all of this stuff, it gives them the ability to do what we call post-death planning. For them to be able to look at the picture at that time and say, okay, which assets are going to be best allocated into the different pieces. So, like if there's a charitable gift, okay, well, if we put the IRA beneficiary to the trust, well, your trustee can look at that and go, oh, we have a charitable gift. Good, I can pay that out of the IRA, and instead of it being a taxable piece of income for the individual beneficiaries, we can allocate all of that over to the charity, and they get the full dollar amount with no tax taken out. Or if there are unanticipated expenses or costs of winding the estate up, or if there are extra taxes, you're not dropping the money into the beneficiary's lap before all of that gets dealt with. If there are none of those, if it's all perfectly exactly how it's supposed to be, what happens with that, I don't know if we have a big marker. I didn't see one in here. Oh yeah, we do. What happens with that is the same thing as the rest of your plan. The IRA simply just goes exactly how it would have gone without going through the trust. So if you put the trust in between as the beneficiary, all it does is it lets it go straight to your beneficiaries the same way. The way we draft our trust here, it's totally, it's tax neutral. Okay? It doesn't increase the tax on the IRA, it doesn't decrease the tax on the IRA. So your beneficiaries will get and set up what is called an inherited IRA for their portion out of this account. There's no tax difference. You'll see that a lot of financial institutions aren't used to this because it's the tax language and the coordinating that tax language to make sure your trust is tax neutral is not commonly used in trusts. So they might want to see that paragraph or that section of your trust before they'll let you do this, and that's fine. It's tucked back in there and all the legalese. So you might run into a little bit of fear from somebody if you're asking them to do this. What the other things I've given you in each of your packets are examples of how this gets done. This is one of the most technical areas to get it done totally right. So use the examples as your guide if you're filling out and updating your IRA beneficiaries. The reason I say it's tax neutral is because when somebody inherits an IRA, we're not talking about a spouse. Okay, when somebody else inherits an IRA, they have the requirement from that day forward to treat it under a different set of tax rules. that say, you, beneficiary, you're required to take out a certain amount of this account every year. Okay? Because the IRS let the owner defer that income. They didn't get taxed on it until they started taking money out. And then the tax rules change when it goes to an inherited person. They can't defer it anymore. They have to start taking out a minimum amount. Well, the tax goal is to, if the beneficiary doesn't need the money, right, if they don't have to get the money, we don't want them just taking it out and triggering extra taxes. So let it sit in there and grow. Well, the longer they do that, we all know the power of compounding interest and long-term growth. I did a calculation for somebody, and basically, if you leave $200,000 to a beneficiary who doesn't need the money, and they just stick it in an account and let it sit there, and they're, say they're in their 50s, well, they're projected to live another 30 years, and I think about a growth rate of about 8%. That $200,000 becomes somewhere around $2 million. So the longer they can just let it sit, right? That's a game-changing amount for the next generation. What might have felt like a modest inheritance now is a family tree changer. So being required to only take out the smallest amount possible over the longest time period possible is really important with IRA accounts. So that's why when you name your trust as beneficiary, they have to know that it's the right type of trust. It can do this without triggering all kinds of problems. And it's tax neutral, so that if you were to leave it directly to the beneficiary or you leave it to them through the trust, they still get to take those distributions out in smaller bits over their lifetime. Okay? The alternative, I'm trying to think if we had any bad examples of this. If you have an IRA that goes to somebody that's not qualified under the tax rules, it doesn't meet all these other requirements, they have to take the whole thing either within 5 years of death, or there's some other exceptions. Well, so that means they take 20% of it basically every year. Well, if you have to take out $200,000 over 5 years, all of a sudden the tax bill bumps you up into the 30-40% tax range. The IRS just becomes one of your primary beneficiaries. So making sure that you don't lose that is very, very beneficial. Okay. Let's look at the forms you have. I didn't give you another set of them, did I, Cheryl?
Yes.
Okay, here. Look there. Oh, she's got one. It's right up. It's right up there. Thank you. Okay. So, the first one is just an inside look at my industry. So this is prepared by another attorney that is in California. And he just put together this note about how different financial institutions, some of them respond to doing this type of change. So if you use any of these institutions, you'll get a little insider look on how they respond and what they're going to ask of you. So that's just kind of for later reading. What I really want to look at are the next two, the Charles Schwab form, and then the next one that's stapled. It's a few pages. I think this one's for Vanguard. Yeah, this is a Vanguard form. It doesn't say it. But these are their actual forms. These are samples about how to designate the trust as beneficiary. The Charles Schwab, if we look at that one first, you'll see that under section 2 it says designate your beneficiaries. It's got all their fine print. Primary beneficiary says 100% wife's name. You would have to fill in all the other blanks, of course, but that's what we're talking about. The primary needs to be the spouse. If you're not married, then you'll move this over. But then to the column on the right, contingent beneficiaries, this is one extra step. What we ask most of our clients to do is to put on this top line 100%, So you would just put 100%, and then you would write, you know, like the Francisco and Nicole Joint Trust dated blah, blah, blah. Okay? That does what we just talked about with one tiny little difference between that and what's on here. So I want to spend a little bit of time on what that difference is, because you get to decide how important that difference is to you and how much you like filling out forms. If you say 100% to the Francisco and Nicole Joint Trust, dated this date, then what happens? I have 4 kids. Okay, we pass away. They go to implement this. My kids are age 8, 6, and 3. There's 2 8-year-olds. So it's going to go in 4 shares, right? So what I talked about earlier was there's this minimum amount the beneficiaries have to take up over their lifetime. Doing this as your beneficiary will mean the 4 of them will use the lifetime of the oldest beneficiary, whose projected lifetime is a little bit shorter than the youngest beneficiary. Okay? So let me just draw that out. Okay. If I have to distribute something in increments of 1, 2, 3, 4, 5, 6, 7, if I have to distribute something out over 6 divisions, so if I have $100,000, in which of these, this top one or the bottom one, who will get a bigger distribution in year 1? The top person or the bottom person? Total math here, right? The bottom person gets a bigger piece because their pie is divided into a smaller number of shares, right? So if they're using the oldest person's age, they're all getting the distributions out over, say the life expectancy is 60 years, here it's 63 years, and here it's 65 years. They're all getting distributions out over 60 years instead of 65 years. So the distribution amounts are a little bit teeny bit bigger here. Okay? The tax difference between using this one or this one in the grand scheme of things is very, very small. The other option, like we've given you here, is to say, so in my example, I would say 25% to Gabriel's trust. And then you can see exactly how it's written down there. And then I would do 25% to Bella's trust. And then 25% to Sophie's trust and 25% to Zachary's trust. And then we'd have a little asterisk for each of them, and then we would say the asterisk means under the Francisco and Sirvent, Francisco and Nicole Sirvent joint trust agreement dated blah, 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 blah. This, doing it this way, lets each of them inherit that IRA using their own life expectancy. Okay, so Zachary, when he inherits it, he's going to get it distributed out over 65 years, but Gabriel's going to have to distribute it out over 60 years. And so that would optimize this to the fullest extent possible under our tax code. If we designate our beneficiaries under IRAs, 401ks, annuities, under all of those tax deferred accounts, if you do it like that. Now, I didn't calculate the numbers for you to tell you what the difference would be in a hypothetical situation. But I know from experience, it's very small. And the headache of doing this on your own is probably not worth that difference mentally to you. Because you're going to have to educate your financial institution on how this works. And when clients hire us to do that, it's almost as expensive as setting their trust up in the first place, because we have to educate the financial institution. The last one I did, what we drafted got referred to, oh my gosh, I can't remember which bank it was. I think it was Merrill Lynch. Got referred to their general counsel, And him and I had correspondence and emails, me telling him how this works. He finally came back and said, great, I understand all this, looks great, we'll approve it. So that's why we don't just out of the gate say, do your IRA beneficiaries like this. Because the tax difference is generally very small, and the headache of doing that is very large. Go ahead.
Is there an age range difference between beneficiary A and beneficiary B when it makes sense to do so? If there's a 10 or a 20 or a 40-year age range, like is there a minimum that?
Not really a minimum. Not really a minimum. You would want to. You could just run hypothetical numbers on that, and running those hypothetical numbers is where I would use our wealth management firm to run those because they've got the software to do it. Me, I'd have to go invent a spreadsheet, and even though I like spreadsheets, I don't need to be inventing spreadsheets anymore. But yeah, when there's a large difference in ages between your beneficiaries, that makes a bigger difference. Because, I mean, if you have, if one beneficiary has a 30-year life expectancy, the other's got a 60, well, holy moly, that's double. So we could give this beneficiary double the growth time period if we set it up like this. Does that make sense? That's kind of what you were thinking, right? So that's how Schwab does it. They're pretty simple. You would just need to write, don't miss this little handwritten asterisk down at the bottom. That's a very important piece of this. And then with Vanguard, their form has more white space, but it's pretty much the same substance. You'll see that on that first page, it just says to the person named here, Janice A. Smith. Presumably that's the spouse. And then there's a little, sub-designation, which is a nice little tax strategy. But if she disclaims to the exemption trust and once fully funded to the marital trust, each established as a separate share under the John Smith IRA Inheritance Trust dated this date. So this is an advanced tax strategy that you could use, but you could skip that part and just name your spouse, or if you're naming your trust, you'll see how that's described on pages 3 and 4. 50% to Paul Smith Trust, established as a separate share under the John Smith IRA Trust, dated 7/109. 50% off to the side, and then the other 50% on the next page. The magic words in there, give the name of the beneficiary. So I would say Gabriel Sirvent Trust, established as a separate share, that's important, under the, and then your own trust name. The Francisco and Nicole Sirvent Trust Agreement. And then the percent. So those are how you could take your IRA beneficiary designations to the next level. But if your beneficiaries have similar close age ranges, then this is much better than naming them individually on that IRA to begin with. The other reason I just remembered that we like life insurance policies and IRAs to be payable to your trust as a beneficiary is that because you can see in these forms, if you just name individuals on here, what happens if one of those individuals predeceases you, or you're on vacation together and something happens to all of you? These forms don't deal with a lot of contingencies. They deal with the here and now. In your trust, we've dealt with contingencies on what happens if this or if that or if this or if that. So if you've named this to your trust, it automatically pulls in all the contingency planning you've done. Okay? Okay, let me run through the last few slides here. Unless there's any questions about IRAs, annuity beneficiaries. You guys got way more tax blah 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 than you were expecting. The other one is, did you have a question? You're like, my mind is swimming right now.
Right, right. Well, we have two daughters, both married, they're 10.5 years apart, and that's it.
Yeah.
Two, so,
So it might, I mean.
We don't have an IRA.
that we know of. No, I don't guess.
Good deal.
So it, never
No, it's
mind.
okay. No, I mean, I'm giving you a lot of info, so as you process things, if you think of questions, let me know. The other beneficiary thing that you can use, though, I wouldn't normally make this a funding strategy, is to use payable on death designations. Bank accounts, of the checking and savings variety, sometimes you can add a POD designation. So that just means you own it while you're alive. It's yours just like it is before you set up a trust. But then the moment you die, that account is owned by whoever you designate there. So you can put your trust as a POD on those types of accounts. And that's fine. But what it totally misses is all the incapacity protection around that account. I will allow my clients to use this strategy if it's the type of savings account that has $600 in it, and I don't know why I'm keeping that account open anymore. I've just had an account at that bank forever. And okay, fine, just at least add a POD to your trust on that account. That's usually the one time I'll bend on that rule. But I want those types of accounts owned by your trust. Because if you become incapacitated, the bank has even with a POD, you're not dead yet, you're incapacitated. The bank has all the authority in the world, to freeze that asset, unless it's in your trust. Okay? We talked a little bit, I'll just make this point. Arizona has a dollar value limit for personal property, which under our probate laws means anything that's not real estate. So if the total value of personal property is under $75,000, there's a very, very simple probate procedure we could use to collect and gather those assets and get them into your trust without having to go through all the formal probate procedures. Usually I reserve that for vehicles and a little buffer for, oops, I forgot about something. So this isn't a planning strategy of, okay, let's try to max out the amount that we can keep out of our trust. No, your trust is there to protect you during incapacity and make it easy to administer everything after you pass. This is the buffer for the just in case, oh, I forgot something. And we can use that, we have used that strategically in cases for that exact type of scenario. So let that sit there, get things into your trust. We've pretty much talked about most of these issues. The bottom one I'll mention, we haven't mentioned it. Uniform, oh my gosh, it's after 4. Uniform minor accounts. Those are accounts set up at a bank where somebody over 18 is the custodian, but it's actually legally owned by the minor. So, you go and say, I want to put $100, in for my grandchild or for whoever. Those accounts can't be owned by, they usually can't be owned by a trust. So what you want to do is designate a successor custodian. Okay, so you can go in there and there's a form that the bank has where you can designate somebody else to be your successor custodian if something happens to you. So you just want to make sure that there's somebody else there to take care of that account if you're not available. Those accounts are 100% owned by the minor on their 18th birthday. Who here in the room knows who Justin Bieber is? Okay, I just learned about him not too long ago. But the reason I really learned about it was because he turned 18 just, I don't know, a couple of years ago or sometime recently.
3 years ago.
3 years ago, okay. Yes, he's terrible. Wow, terrible. I'm so disconnected. 3 years ago, he became the wealthiest 18-year-old in the world. His estate was worth something like $17 billion. Because that's all the, work and intellectual property he had created while he was a minor, but all of it was created, that's the only way it could have been created because it was him generating the revenue. under these types of arrangements. Okay? If you're giving money to somebody who's a minor, you need to know this type of arrangement means they own it all on their 18th birthday. It's a surprise he didn't drive off a cliff somewhere on his 18th birthday in his brand new who knows what vehicle, right? So, just make sure you know that.